Someone got drunk at my party and had an accident, am I liable? In some parts of the United States, the social host liability law suggests that anyone who hosts an event could be liable for injuries if they provide alcohol to someone who is then involved in a car accident. Not every state has this law, but those that do could find a host liable if the individual driving the car was intoxicated. Let's imagine that at his party Trevor offered Phil some wine and Phil decided he was going to drink too much of it. Trevor encouraged Phil to continue drinking, even though it's clear he was already quite drunk. Upon leaving the party in the early hours of the morning, Phil decides to drive home, and while driving he hits Beth's car, injuring her. In every single part of the United States, Beth would be able to bring about a personal injury case against Phil. If the state where the accident took place also had the social host liability law, then Beth could also make a claim against Trevor. However, this does depend on the state and the statute itself. If Phil was found to be under the age of 21 when he had the accident, Trevor should have known that he wasn't legally allowed to drink. Trevor also should have known that Phil was going to drive home. Some states have legislation that prevents the host from having a claim made against them if their guest had too much to drink before the accident. A guest who became intoxicated at a party may not be able to sue the person who provided them with alcohol. This means that Phil would not be able to sue Trevor even if Trevor encouraged him to drink. However, if it was found that Phil was a minor at the time of the accident, then he may be able to file a lawsuit against Trevor.